Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. This is a continuation of a two-part series on how Judge Stephen J. Hippler might instruct the citizens of Ada County who are summoned to the courthouse this summer to serve as part of the potential jury panel during Voir Dire, which is set to occur July 30th, 2025, if he were to rely on instructions that have been approved by the Idaho Supreme Court and that are published on the Supreme Court's internet page. If you would like to review this entire instruction in total, please go to part 1 of this two-part series. It was published yesterday, March 31st, 2025. When we left off during part 1, we learned here that the court would, if relying on these instructions, say the following: we will now call an initial selection of and insert the number of jurors to be called jurors. As your name is called, please take a seat as directed by the bailiff. The clerk will please draw the initial jurors' names. And then at this point, the clerk would call the names of the jurors. Once that occurs, the instruction continues. In this part of the jury selection, you will be asked questions touching on your qualifications to serve as jurors in this particular case. This part of the case is known as the Voir Dire examination. Voir Dire examination is for the purpose of determining if your decision in this case would in any way be influenced by opinions which you now hold, or by some personal experience or special knowledge which you may have concerning the subject matter to be tried. The object is to obtain 12 persons who will impartially try the issues of this case upon the evidence presented in this courtroom without being influenced by any other factors. Please understand, this questioning is not for the purpose of prying into your affairs for personal reasons, but is only for the purpose of obtaining an impartial jury. Each question has an important bearing upon your qualifications as a juror, and each question is based upon a requirement of the law with respect to such qualifications. Each question is asked of each of you as though each of you were being questioned separately. If your answer to any question is yes, please raise your hand. You will then be asked to identify yourself both by name and juror number. At this time, I would instruct both sides to avoid repeating any question during this voir dire process, which has already been asked. I would ask counsel to note, however, that you certainly have the right to ask follow-up questions of any individual juror based upon that juror's response to any previous question. The jury should be aware that during the voir dire examination, one or more of you may be challenged. Each side has a certain number of preemptive challenges, by which I mean each side can challenge a juror and ask that he or she be excused without giving a reason therefor. In addition, each side has challenged for cause, by which I mean that each side can ask that a juror be excused for a specific reason. If you are excused by either side, please do not feel offended or feel that your honesty or integrity is being questioned. It is not. The clerk will now swear the entire jury panel for the voir dire examination. This now concludes this instruction of how Judge Hippler might instruct the members of the voir dire panel when this matter is raised on July 30th, 2025 during voir dire. What I also wanted to share with you is an additional instruction. This is the recess instruction. This is what would be said, words to these effect, to the members of the voir dire panel or the actual jury when recesses are called. And this might be for lunch, for breaks, during a time when perhaps an objection is raised, when the court needs to resolve the objections and feels that it should be done outside of the presence of the jury. According to ICJI 002, the recess instruction is as follows. During the course of this trial, including the jury selection process, which, ladies and gentlemen, is voir dire, you are instructed that you are not to discuss this case amongst yourselves or with anyone else, including any use of email, text messaging, tweeting, blogging, electronic bulletin boards, or any other form of communication, electronic or otherwise. Do not conduct any personal investigation or look up any information from any source, including the internet. Do not form an opinion as to the merits of the case until after the case has been submitted to you for your determination. This will now conclude this second part of a two-part series on voir dire, which again, ladies and gentlemen, is now less than 4 months away. This is Kathy. Thank you very much for joining us here today.